On January 25, 2017, just 5 days after taking office, President Donald Trump signed Executive Order 13,768. The title sounded routine, enhancing public safety in the interior of the United States. It wasn't routine. The order targeted so-called sanctuary jurisdictions, cities and states that limited cooperation with federal immigration enforcement. It directed the Attorney General and the Secretary of Homeland Security to ensure that jurisdictions refusing to comply with 8 U.S.C. Section 1373 could lose certain federal grants that meant money, federal law enforcement grants, public safety funding. Millions of dollars that cities rely on every year. California immediately became ground zero. At the time, California was home to an estimated 2.3 million undocumented immigrants, the largest population of any U.S. state. Major cities like Los Angeles and San Francisco had long-standing policies limiting local law enforcement's role in federal immigration enforcement. Then the state went further. On October 5, 2017, Governor Jerry Brown signed Senate Bill 54, the California Values Act. SB 54 prohibited state and local law enforcement from using their resources to assist federal immigration authorities in most cases. Police could not hold individuals solely on ICE detainers without judicial warrants. Local agencies were restricted from sharing certain information about release dates. This wasn't symbolic. It was a direct policy wall between Sacramento and Washington. Los Angeles Mayor Eric Garcetti defended the position publicly, stating that trust between immigrant communities and police was essential for public safety. San Francisco Mayor Ed Lee and later London Breed echoed the same message. Local law enforcement would not be turned into federal immigration agents. The Trump administration responded fast. In March 2018, then Attorney General Jeff Sessions announced a lawsuit against the state of California, arguing that SB 54 interfered with federal immigration authority and violated the Supremacy Clause of the U.S. Constitution. Sessions stood in Sacramento when he made the announcement. The symbolism was deliberate. He accused California of actively obstructing federal law enforcement. The legal argument centered on whether states could refuse cooperation without crossing into obstruction. Under the 10th Amendment, states cannot be compelled to enforce federal law. That principle had already been reinforced by the Supreme Court in Prince v. United States in 1997, but the federal government argued that California's policies went beyond passive refusal and actively undermined federal enforcement efforts. The financial pressure escalated. The Department of Justice attempted to condition Edward Byrne Memorial Justice Assistance grants, known as Byrne JAG funds, on immigration cooperation. These grants support local police equipment, anti-gang programs, and public safety initiatives. Cities like Los Angeles and San Francisco stood to lose millions. California sued, so did multiple cities across the country. On April 25, 2019, the 9th U.S. Circuit Court of Appeals ruled largely in California's favor, allowing SB 54 to remain in effect. The court found that while the federal government has supremacy in immigration enforcement, it cannot compel states to use their resources to carry it out. That ruling was a major blow to the administration's strategy. The constitutional line had been tested and clarified. The president could enforce immigration law, but he could not force California to help. What began as an executive order had turned into a full-scale constitutional showdown between the White House and the most populous state in America. And this was only the opening battle. The conflict intensified in the spring of 2018, when immigration enforcement moved from courtrooms to the border itself. On April 4, 2018, President Trump signed a memorandum directing the deployment of National Guard troops to the U.S.-Mexico border. The move came amid rising political pressure over border crossings and public debate about caravan movements from Central America. Unlike active-duty military deployments under Title 10 authority, this operation relied on Title 32 status, meaning National Guard troops would remain under the control of their state governors while receiving federal funding. That distinction mattered. It meant cooperation was required. Governors had operational control. And California's governor at the time, Jerry Brown, did not hand over that control lightly. Governor Brown agreed to deploy approximately 100 California National Guard troops, but he placed strict limits on their duties. They would not participate in immigration enforcement. They would not conduct detention operations. They would not perform direct law enforcement activities. Instead, they were assigned to logistical and support roles, including vehicle maintenance, surveillance analysis, and counter-drug operations. Brown made it clear in his April 2018 letter to the federal government that California's participation would focus on transnational criminal gangs and drug trafficking, not federal immigration raids. This was not a full endorsement of the president's strategy. It was conditional cooperation, carefully defined. The tension deepened when Gavin Newsom became governor in January 2019. On February 11, 2019, Newsom formally announced that he would withdraw the majority of California National Guard troops from the border mission. At the time, roughly 360 California Guard members were assigned to the deployment. Newsom redirected many of them toward wildfire prevention, infrastructure protection, and counter-narcotics work within California. In his official statement, he declared that the border emergency proclaimed by President Trump was not the crisis it was portrayed to be. That public rejection of the president's framing elevated the dispute beyond policy differences and into open political confrontation. This shift came during a larger national dispute over border wall funding. On February 15, 2019, President Trump declared a national emergency under the National Emergencies Act in order to redirect billions of dollars in federal funds toward border barrier construction. After Congress declined to provide the full amount he requested, California joined a coalition of states challenging the emergency declaration in federal court. The lawsuit argued that redirecting funds without explicit congressional authorization violated the Appropriations Clause of the Constitution. The legal and political battles were now running parallel, National Guard authority on one side, emergency funding powers on the other. The National Guard issue underscored a constitutional reality that is often misunderstood. Under Title 32, governors retain command and control of their Guard units, even when federal dollars fund the mission. A president may request deployment, but operational authority remains at the state level unless federalized under Title 10. Trump did not federalize California's Guard during this confrontation. Doing so would have dramatically escalated the conflict, effectively stripping the governor of control. The fact that it did not happen reflects the seriousness of the constitutional boundary involved. Federalizing a state's Guard over political disagreement would have triggered immediate legal and political shockwaves. By mid-2019, the clash had evolved into something larger than border logistics. It had become a visible demonstration of competing interpretations of federal authority. The White House framed border enforcement as a national security imperative requiring unified action. California leadership framed it as a matter of state sovereignty and resource allocation, especially given the state's escalating wildfire crises, which had already caused billions in damage in 2017 and 2018. The redeployment decision was not just symbolic, it reflected a strategic decision to prioritize state emergencies over federal immigration operations. The standoff exposed a fundamental question that continues to echo. When federal and state leaders fundamentally disagree on the nature of a crisis, who defines the emergency and who controls response, the battle between the Trump administration and California was not just about policy. It was about money and leverage. And the numbers were serious. In 2017, the Department of Justice moved to attach new immigration-related conditions to the Edward Byrne Memorial Justice Assistance Grant Program, commonly known as Byrne JAG. This program distributes hundreds of millions of dollars annually to states and local governments for law enforcement initiatives. The funds support anti-gang operations, drug task forces, police equipment purchases, crime victim services, and community safety programs. California jurisdictions receive tens of millions each year through this program alone. The administration announced that jurisdictions would be required to comply with federal immigration information sharing rules under 8 U.S.C. Section 1373 and allow federal immigration agents access to detention facilities in order to receive funding. Cities like Los Angeles and San Francisco were directly impacted. In fiscal year 2017, California agencies were allocated approximately $28 million in Byrne JAG funding. Losing that money would have had immediate operational consequences for local policing budgets. San Francisco and Santa Clara County filed lawsuits challenging the conditions. They argued that the executive branch did not have unilateral authority to impose new requirements that Congress had not approved. The legal issue centered on the spending clause of the Constitution. Congress controls federal appropriations. The executive branch cannot rewrite the terms after the fact. On November 20, 2017, U.S. District Judge William Orrick issued a nationwide injunction blocking enforcement of the executive order's broad, funding threats against sanctuary jurisdictions. He ruled that the administration likely exceeded its constitutional authority by attempting to impose new funding conditions without congressional approval. The decision was a major setback for the White House strategy of financial pressure. The legal fight continued through 2018 and 2019. Multiple federal courts ruled against the administration's attempt to attach immigration conditions to Byrne JAG grants. Eventually, the Ninth U.S. Circuit Court of Appeals ruled in favor of California's position, holding that the Department of Justice could not impose conditions that Congress had not clearly authorized. Similar rulings came from other circuit courts across the country, creating a consistent judicial barrier against the funding strategy. At the same time, California's vulnerability to federal funding was enormous. The state receives billions annually in federal support across sectors. In fiscal year 2019 alone, California received over $100 billion in federal funds, including Medicaid support, disaster relief, transportation funding, education grants, and law enforcement assistance. Any serious disruption would have created widespread consequences. Disaster relief funding added another layer of tension. California experienced catastrophic wildfires in 2018, including the Camp Fire in November 2018. Which became the deadliest wildfire in state history, killing 85 people and destroying over 18,000 structures. Federal Emergency Management Agency assistance was critical. While disaster funds were not formally cut, public statements from federal officials raised concerns about whether political conflict could influence emergency support decisions. That uncertainty alone amplified pressure. The funding dispute revealed a structural limitation on executive power. Courts repeatedly reinforced that while the federal government can set conditions on grants, those conditions must be clearly authorized by Congress and directly related to the purpose of funding. Expanding immigration, enforcement through indirect financial coercion, ran into constitutional resistance. The result was clear. The financial squeeze strategy failed in court, but the confrontation left a lasting impact. It demonstrated how federal grants could become political weapons, and how states could use the judiciary to block executive overreach. This was no longer just a disagreement over immigration. It was a test of whether financial power could override state autonomy. And the courts had drawn a line. In February 2018, the confrontation moved from policy memos and court filings to neighborhoods and workplaces across Northern California. U.S. Immigration and Customs Enforcement launched a multi-day enforcement operation in the Bay Area beginning on February 18, 2018. According to IC, the operation targeted individuals with prior criminal convictions and prior removal orders. By the end of the sweep, IC reported that 232 people had been arrested, but the headline wasn't just the arrests. On February 24, 2018, Oakland Mayor Libby Schaaf publicly warned residents that IC agents were preparing to conduct enforcement actions in the area. She cited information that federal authorities were planning raids within 24 hours and urged undocumented residents to know their rights. Schaaf stated that her goal was to protect families and maintain trust between immigrant communities and local law enforcement. IC leadership reacted immediately. Then IC Acting Director Thomas Hamann accused Schaaf of endangering federal agents and allowing hundreds of targeted individuals to evade capture. Hamann claimed that approximately 800 individuals had been targets of the broader operation and suggested many avoided arrest because of the public warning. He stated that local officials had put politics over public safety. The clash was immediate and national. Federal officials argued that local leaders were actively interfering with lawful enforcement operations. Schaaf responded that Oakland police were not notified of the operation and that her responsibility was to her constituents, not federal immigration strategy. The legal question centered on whether warning residents constituted obstruction or was protected speech under the First Amendment. No federal charges were filed against Schaaf, but the episode intensified the broader lawsuit the Department of Justice had already filed against California in March 2018. The DOJ challenged three specific California laws: SB 54, the California Values Act, AB 450, the Immigrant Worker Protection Act, and AB 103, which authorized state inspections of immigration detention facilities. The administration argued these laws collectively obstructed federal immigration enforcement and violated the Supremacy Clause. On July 5, 2018, U.S. District Judge John Mendez issued a mixed ruling. He declined to block SB 54, allowing California's sanctuary law to remain in effect. The court ruled that under the anti-com endearing doctrine, the federal government cannot require states to use their resources to enforce federal law. However, parts of AB 450 related to employer restrictions were limited. The ruling reinforced a constitutional distinction. States cannot directly interfere with federal enforcement, but they are not obligated to assist it. That distinction became the legal backbone of California's resistance. The ICE raid controversy also exposed deeper operational tension. Federal authorities depend on cooperation from local jails to transfer custody of individuals flagged for removal. California's restrictions limited information sharing and detainer compliance unless backed by judicial warrants. ICE argued this reduced efficiency and increased risks. California officials argued that community policing collapses when residents fear reporting crimes due to deportation threats. By 2019, the pattern was established. Federal agents would conduct targeted enforcement actions. California leaders would publicly reaffirm sanctuary protections. Lawsuits would follow. Courts would define the boundaries. The political rhetoric intensified, but the legal structure remained intact. Immigration enforcement is federal authority, yet federal power has limits when it seeks to compel state participation. The ICE raids made the conflict visible, not abstract, not theoretical, agents at doors, mayors at podiums. Federal officials accusing obstruction, state leaders citing constitutional protection. The clash was no longer confined to Washington. It was unfolding on city streets, and the legal line between enforcement and overreach was being tested in real time. By the end of 2019, the clash between the Trump administration and California was no longer just a dispute over immigration tactics. It had evolved into one of the most aggressive federal, state legal battles in modern American history. From January 2017 through January 2021, California filed or joined more than 120 lawsuits challenging actions by the Trump administration across immigration, environmental policy, healthcare, census rules, and federal funding authority. No state had ever mounted opposition at that scale. Immigration remained the most explosive front. At the center of the fight were two constitutional forces pulling in opposite directions. The Supremacy Clause of Article VI establishes that federal law overrides conflicting state law. But the 10th Amendment protects states from being commandeered into enforcing federal regulatory programs. The Supreme Court had already reinforced this boundary in Prince v. United States 1997, ruling that the federal government cannot compel state officers to execute federal law. That precedent became California's shield. The Trump administration attempted to test the outer edge of executive power using two primary tools: conditional federal funding and emergency authority. Courts repeatedly limited both. In multiple rulings between 2017 and 2020, federal judges held that the executive branch cannot attach new conditions to congressionally authorized grants without clear legislative approval. The judiciary also scrutinized the 2019 National Emergency Declaration, used to redirect funds for border barrier construction. While parts of that emergency action were initially upheld, other aspects were blocked before later being halted under the next administration. The broader legal outcome was significant. Federal courts clarified that immigration enforcement remains exclusively federal, but cooperation from states must be voluntary unless Congress explicitly legislates otherwise. That distinction narrowed the executive branch's ability to use financial pressure as a compliance tool. The numbers show how high the stakes were. California's annual federal funding intake exceeds $100 billion, covering Medicaid, infrastructure, disaster relief, and public safety. A serious funding disruption would ripple through hospitals, schools, emergency services, and local law enforcement. Yet courts repeatedly signaled that threatening wholesale withdrawal of funds would likely violate constitutional spending limits established in cases such as N. Fib v. Sebelius 2012, where the Supreme Court ruled that the federal government cannot coerce states by threatening to withhold existing major funding streams unrelated to the policy dispute. The confrontation also created a blueprint for other states. Several jurisdictions across the country adopted or expanded sanctuary-style policies after courts reinforced endearing protections. The legal precedent strengthened state autonomy in politically charged policy areas, not only immigration. The long-term implication is structural. Future presidents, regardless of party, face clearer judicial guardrails when attempting to pressure states into compliance. Executive authority remains powerful in immigration enforcement, border security, and federal law execution. But the Trump-California standoff demonstrated that state governments can resist federal directives through litigation, and that courts are willing to define hard limits on executive leverage. This was not simply partisan resistance, it was a constitutional stress test. Federal supremacy was asserted, state sovereignty was asserted, the judiciary became the referee. The larger question remains unresolved and deeply consequential. In a politically divided nation, how far can a president push federal authority before courts intervene? And if future crises involve more than immigration, public health, internal security, environmental regulation, will those same guardrails hold? The battle between Washington and California did not collapse the constitutional system. It exposed its fault lines. And those fault lines are still there.